Okay, bad faith listeners, faithful as it were, I am so excited to have a guest on today whom I've alluded to innumerable times as one of the most formidable, foundational professors in my life, someone whose teaching impacted my political development, perhaps more than any other kind of single moment in my educational career. It's Professor Jon Hanson. He's the Alan A. Stone Professor of Law and Director of the Systemic Justice Project at Harvard Law School. Welcome to Bad Faith Podcast, Professor Hanson.
Thank you, Briahna. First of all, I just would like to end the podcast now. I think that is a perfect place to end. It will only go down from here. And second of all, you must call me John if you can tolerate it.
I think I can muster it up. It's a hard habit to break, but I'll do my best.
Okay.
Now, you joke that this is going to go downhill from here, and I know that you were a little reluctant to come on. I've been begging you for a while now, but I don't understand why, because I'm like reading your intro here off the Harvard Law site, and you've won like the Teacher of the Year. There's like multiple Teacher of the Year awards that you've won multiple times, including I remember you getting it the year that I had you for my Section 6 section leader. And it boggles my mind that you could ever think that this would be anything less than a studying conversation.
Okay. Well, I mean, you act as if I'm somehow rational or you're rational, but first of all, go Section 6. I want to say that. And second, Briahna, I don't like little bits of onions in my food. Okay. And there's no explaining that. If they're much smaller than that, I think they're delicious. But little chunks get me. And recorded interviews really have a thing. So I would only do this, I think, with you. Maybe this will be the thing that breaks my phobia.
I really hope so, because here's the thing. Here's why I think your lessons were so transformative for me. One, I had you for tort law in Section 6 as a first year, as a 1L. And then I had you as a corporate law professor. And I was one of those people who kind of knew they were going to go and practice corporate law. The idea being I was going to do it for a few years and pay off my loans, like so many people say, and then they get stuck. And I knew I had to take corporate law, didn't want to take it. And word on the street was your corporate law class wasn't, your grandma's corporate law class. It was something different, that it had this social justice angle. Obviously, I knew you from Section 6. I didn't entirely know what it meant to have a progressive corporate law professor, but I had to take it, so I signed up. And I gotta say, it delivered so much more than I expected, in part because it gave me language to understand systemic injustices through our legal system in a way that I think that sometimes most of us have this kind of sociological approach to it. We might take Social 101 and we learn how to say things like systemic this and systemic that and systemic racism. And that's all good and true, but there's something very kind of concrete and almost scientific about the law that I think is harder for some folks who might dismiss some other kinds of systemic racism and social justice and inequality. It's harder for them to dismiss it when they see the way it's baked in so structurally into the legal system. And it empowered me to talk about the ways in which the world was rigged, that I found to be much more persuasive to folks who might not be down for just your regular schmegular degular conversation about racism. So I want you to, I want to frame this conversation in the context of the Norfolk Southern rail catastrophe in East Palestine, Ohio. Because the instant that I heard about that crash, I thought back to your class. And I thought about the lessons, how you spend basically a semester talking to us about how the legal system incentivizes corporations to engage in these kinds of risk-taking behaviors, precisely because it does not punish them for all of the costs of those behaviors. So I don't know where exactly you want to start with that, but for someone who might be, not know anything about liability standards and how the law can shape the outcome in these kind of cases, I want to know what was your first reaction when you heard about this crash?
Well, thank you for that introduction, a second introduction, and that summary of your experience at the law school. It's not uncommon, although unlike yours, a lot of students come thinking they want to go to law school and pursue justice, and then find themselves going into corporate law. In terms of the framing of these issues of race, racial inequality, and systemic injustice, one reason why the language is helpful that I provide is not that it's better language than otherwise is out there. I think some people say these things much better and have been thinking about them longer than I have. It's that I give sort of a complementary alternative story in my progressive approach, where my experience was born of sort of a deep dive into tobacco documents back in the 1990s, and then a very thorough immersion in mind sciences and social psychology, where I picked up language and concepts that then I sort of use in my class. And that's some of what I think you were picking up. So I appreciate what you have done with that language and your work, and made it even much more accessible than I could. As to the question about what did I think when I saw the headlines and some of the reports on what was happening in East Palestine, it was a pretty automatic reaction that pairs with or responds to a sort of the tort law class that you took, that I believe at the time, Briahna, culminated in sort of an overview of a case called Indiana Harbor Belt versus American Cyanamid, which is a railroad toxic spill case. And in it, a very famous, probably the most famous 20th century judge, the most cited 20th century judge, held for the chemical company that they would not, in effect, be strictly liable. And I won't go into the details of that. Perhaps later I can, but my reaction was strict liability. There should be strict liability. It was just my quick thought, which is my reaction after many years of seeing large corporations across many contexts avoiding liability, avoiding accountability because of the way the law is, as you put it, rigged. But if I may, I'd love to, if I can, try to give you an overview of three years of law school that you went through.
Please. Everyone should have the privilege. Absolutely.
So this is an hour-long, roughly, podcast, so I think I can get this down to, a few minutes. But I mean, as you know, the deal with law school is that we can charge a lot of money and bring people for several years to give up other things they might be doing because law is really complex, and it's it's got processes and procedures and a whole bunch of doctrines, and then any number of modes of interpretation that you have to learn. And then there's the kind of more realistic assessment that steps back and says what's really going on. And so there's legal theories. All of that is sort of part of what legal education entails. But if you look very basically at what law school is, it's the overview of doctrines that are not accidental. The doctrines that are taught in law school were designed to be taught in the late 1800s and have been taught more or less since then. And they are doing something. And it's worth just very simply sort of giving an overview to those of your listeners who are not lawyers or law students. In your first year of classes, what we call 1L, you were required to take, as generations before you had been, courses on property, contract, tort law, and criminal law. There are some others that have been added since, but those were the basics. And if you think about what those courses do, essentially they start with the premise of law, which is that we are not going to talk about systems. We're not going to talk about structures. We're not going to talk about history. We're not going to talk about distribution or power or racial prejudices or any of the context and circumstances that we know in real life are shaping what happens between people and groups in our society. All of that is going to be erased in our analysis. And instead, we're going to talk about doctrines. And those doctrines are premised fundamentally on a conception of the human being and what moves an individual person. Now, this is a fabricated psychology that law has adopted and that is, not uncommon in our society, which is that what happens to a person or a group is a consequence of something about them, something about their personalities, their preferences, their strengths, their weaknesses, something about them that leave us concluding that whatever happens to them is what should happen to them, is as it ought to be. So if it's a good thing, then they deserve it. If it's a bad thing, then they deserve that. And it's the essence of, this notion of a meritocracy and so forth. But all of that is built into the assumptions of law before you even start talking about anything, right? Before you talk about any problem or any case, that's just baked in.
The just world hypothesis.
The just world hypothesis, exactly. And so what happens is just. That's right. And so that you've referenced a bunch of social psychological studies that people tend to imagine the world is just, and they interpret it and provide stories that affirm that. Okay, that's a lot of wind up to start talking about the cases. Should I pause, or am I doing okay?
No, I think that's great. You're actually reminding me. I've just had like a flood of of memory, because I think it was probably on the first day of torts or the first week or so of torts, where you asked the class. I think the context of the case was involved a young Irish girl immigrant who was coming to the United States and at Ellis Island was vaccinated, and it was compulsory for entry into the United States, but she couldn't read, and she had a bad reaction to the vaccine, and the question was whether or not she could sue. Mm-hmm. And the court decided that she assumed the risk, that she said yes to the vaccine, and you asked us to consider whether or not she was really in a position to assume the risk. Could she really understand the printed signs about the risk if she couldn't read, given her age, given the authority that a man in a white coat with a needle in his hand presents? And then you ask the class, to think about the perspective that the judge was coming from versus the constituencies that might be better served by having more leniency in the law. So you asked us basically, who should the law protect? Actually, maybe that was corporate law. Who are the vulnerable constituencies that the law should be designed to protect? If you were going to set up a legal system, who would you consider to be the focus of the protection of that legal system? And you said a bunch of things: kids, the environment, animals, other vulnerable parties. And you're like, well, no, the corporate law, the choice that has been made is that the most vulnerable people that we should protect is the shareholder. And that's like a real eye-opening moment for a lot of folks, because I think that in a normal corporate law class, probably you're just told, hey, straight up, the purpose of corporate law is to protect a shareholder, without ever interrogating whether or not that's how our law should be designed.
Right. So your memory is perfect, and except for the fact that you have split the two classes.
I have, combined them.
But it's all good. If I may, I'll try to distinguish a bit and then combine them. But I do want to say that one drawback of the podcast, Briahna, is that my current students are saying, "Oh, he's been teaching the same class."
Why improve on perfection?
Right. Thank you, Briahna. To the first example, it's Mary O'Brien was the plaintiff's name, and your summary was adequate for our purposes. Essentially, what the court wanted to do was to interpret what happened between this Irish immigrant coming across, sort of underage, coming across from a really dire situation in Ireland to a similarly dire situation in the U.S., and separated from her dad. Her mom had passed away, unable to read and understand what was going on, puts herself at the end of this long line that are down, under, in steerage, and then are forced to go up through this line before this English doctor, a male white doctor, and several stewards before she could exit and rejoin her dad to be allowed to leave. She had said, I think, I've been vaccinated before, and essentially the doctor was not taking that as an answer, and the fact that she presented her arm in response notwithstanding the very clear manifestation of hesitancy and doubts and uncertainty, the court says that's consent, good enough. And what that illustrates is this phenomenon I was describing before, that what the law wants to do is to see consent, particularly when bad things happen. It wants to identify something in the relationship that it can name consent, because once it calls it consent, the law can step back. We can say it's just, whatever happened is as it should happen. Whereas if you just take a look at the context, as I was saying earlier, there was nothing really consensual about this at all. In every way that she could, given the power disparities, she indicated that she did not want to have that vaccination. So that's an illustration. And if you look at the basic first year courses, property basically says, if you have a lot of wealth, perhaps inherited wealth, or money or income or anything, we are going to prioritize that as the number one value in our legal system. What is that? Your ability to decide based on your choice from that position of possessing a great deal of wealth, whether or not you will reallocate it in some way or not. And the way that we will have you reallocate will use the state to protect that. And the only way people can get some of it is if they trade. Now, we're going to then put you in a situation where you will be in power disparities with other groups and individuals, some of whom will be hungry and desperate, some of whom will have few alternatives, and we're going to call that contract law. Now, sometimes between equals, contract looks really nice, and it's to be appreciated for what it does. But when we have essentially these tremendous wealth and power disparities, the contract just reflects that.
Yeah.
If you're hungry, the contract is going to reflect how hungry you are. If you don't have another job, if you have a child who's sick, all of those things will be reflected in the contract price. If there's someone else behind you who will do the work for less, that will reflect what your wage is. So power disparities are going to be built into contract, but we pretend that contract is all about freedom.
Right.
It's liberty.
I remember you. Yeah, go ahead. I'm sorry.
No.
I remember you illustrating, because your focus is law and economics, if I recall correctly. And I remember, I guess this is probably in torts, you having these charts that explained, these economic principles like willingness to pay equals ability to pay, and very early interrogating that presumption using the kinds of examples that you just set out. Obviously, if you're sick, you are willing to pay anything to get well. But as we all know, living through the horror that is America's healthcare system, many people are precluded from getting the healthcare that could completely cure them, or life-sustaining healthcare. And people die in the United States of America from not being able to access things like insulin every day. So it was very empowering to have access to, I think, those kind of economic principles, have a clear illustration of why they don't map, the assumptions that are made don't map onto human behavior in the least. And then going back to this just world hypothesis that you were talking about before, I remember you making the following argument, that change happens in the world basically when the just world hypothesis fails, when inequality and injustice and the way things are shaking out are so acute that we can no longer pretend that when bad things happen, it's because people are bad, and when good things happen, it's because they are meritorious and it was deserving. And then we have a kind of a social movement. But that's so much of what we get in advertising and in politics in between those times is stuff that we're being fed to make us acquiesce to the conditions that we're living in. Am I remembering that sort of correctly?
So good. It's so good. I'm going to give Dean Scholar Prize quality answer.
It's hilarious because I was such a mediocre law student.
Well, it's aged really well. So it's really a wonderful summary. I mean, what's happening is that we live in a legal, in a system where the legal system reflects the cultural common sense. Not that there isn't a competition and isn't contestation about these basic stories, but the basic stories in our culture are that what happens to anyone is a consequence of their choice. And by the way, that's a wonderful thing. And on that notion, we build this idea that who you are is what you consume, what you buy, right? That your identity is a result or is manifested through the choices you make. And so, we have opened up this set of markets for you. The more chances you have to purchase and express yourself, that's what freedom looks like. All of that is based on the same conception of the person. And again, those are the stories that leave us feeling indifferent to the harmful consequences of what we describe as consumption choices, free consumption choices. This is why tobacco, evades liability for decades and decades, and meaningful regulation, and manages to kill, hundreds of thousands of people per year in this country alone, and also valorizes and celebrates that it's all about freedom and freedom of choice. So that works there. It works more generally. I want to get back, if I can, to trains and to torts a little bit. So
please.
If you understand property and contract all based on this idea of consent, and essentially what that is going to do is it's going to reinforce existing distributions of wealth and income and property, and enhance it depending on power disparities. And then you have criminal law. What is criminal law but an intervention of the state using violence to back up property law should people decide to reallocate things without consent, and it meets other criteria that are somewhat specified. We will step in and say they're not playing by the rules and punish them, often incarcerating them, sometimes killing them, and that reinforces property and contract and really the existing distribution of resources. Now, add to that tort law. What is tort law? Very simply, it's the space of law that deals with the circumstances in which we can't plausibly say consent was possible. Two people meet by accident in a car crash, right? It's not feasible to say they could have contracted ahead of time. So what do? We impose upon them a result. And in that imposition, what we often do is replicate the same story. So Mary O'Brien, she gets a vaccination that has harmful effects on her body. We say she consented to it. So again, consent just reemerges in that space. Contract just reemerges. Now, let me go to Indiana Harbor, the case I mentioned before. This is Richard Posner, Seventh Circuit judge, arguably the father of law and economics, this very major legal theory that dominated the late part of the 20th century and still is really important for shaping how we understand our laws. What he argued in a case in which American Cyanamid, then a chemical company, transporting a chemical called acrylonitrile, a flammable toxic chemical, from Louisiana through the south side of Chicago, a little switching yard in Riverdale, Illinois, and then if it had continued eastward towards New Jersey. What he argued is that the rule that should apply in a case in which there is a spill that, let's say, victimizes a whole residential neighborhood, is one of negligence. Now, that doesn't mean anything to anyone. So let me say a little more. Okay, so there's this talk that I'm reading that I think is really useful. The environmentalists are calling these trains that are pulling, large train cars of very flammable, toxic, explosive chemicals around the country. They're sometimes referring to them as bomb trains, right? Because essentially that's one way of looking at it. There are people who make money by taking chemicals and putting them in a car and transporting them to send them to somewhere else. So there's the sender who's making money by sending them. And then there's people who are making money doing the transporting itself. And what they're doing is really creating a set of situations in which inevitably and predictably, but not not down to the specifics, somewhat randomly, in other words, there will be bombs. These things will go off. They will do a lot of harm to the environment, to the people, to the future of a community or space. Well, the way it's set up now is those people who do the sending and transporting, they're presumptively not responsible for what happens. Presumptively, the people who are harmed, the communities who are harmed, are responsible. And the question is, well, what do you need to do to overcome that presumption? That's where tort law fits in. The presumption, weirdly, is they have to actually get a lawyer. They have to try to make a case. They have to prove a bunch of facts to show that something, some threshold, some doctrinal sort of hurdle was overcome by the defendant, and they've got to, and therefore they have to pay. And the question is, what is that hurdle? What's that threshold? First of all, it's ridiculous that that should be the presumption. The presumption is the ones that are profiting from it should pay. The people in the community clearly, I mean, it's just intuitive, shouldn't have to absorb the costs, which are sometimes absolutely devastating for a community and individuals. So what the law does is it gives rules, and it suggests in the giving of those rules that it is reasonable, and it is appropriate, and it is legitimate, and it is good. Now, the rule had been, in the middle of the 20th century for a case like this, the rule had been something we call strict liability, which is pretty generous for plaintiffs. Basically says you show that there's a causal connection between this harm and this act and this harm, and we'll have the actor pay. It was something under the doctrine of abnormally dangerous activities. What Richard Posner did in the 1990s was say, no, we don't really need strict liability. Let's adopt a standard that is harder to meet called negligence. You have to show that these transporters, those who are producing these chemicals, did something wrong, unreasonable. Why? I mean, why would you ever say that among the parties, the community who's been victimized by this has to show that someone else did something wrong? Answer is because that advantages the people who are transporting bomb trains, right? These train cars that are so explosive. And essentially what that meant in this case, he overturned a lower court had held otherwise, was that this case was not going to get a meaningful remedy. And the people in that community, in generally, in other cases like this, weren't going to have a meaningful remedy. And that meant that transporters and those who produce these chemicals were going to be insulated from the consequences of their profit-making activity. It's ridiculous.
What rationale did Judge Posner give? And I mean, I know that I'm not going to agree with it, but did he even try to come up with an explanation for why he would basically constructively lower the liability standard for corporations other than, I'm a sociopath?
Well, I mean, he is Richard Posner, and he is, kind of infamously kind of, I don't know, like numb to, it seems, human suffering. But I'm going to treat him as totally in good faith and thoughtful. And what he did is what judges do. He provided an elaborate collection of reasons that if you read them, especially as someone who didn't have at all a critical lens or was unfamiliar with the whole landscape of law, would say, that makes sense. So he layered in an analysis of precedent and basically said precedent doesn't control here, so I've got to figure it out myself. Then he said, well, how am I going to figure it out? Easy. I'm a legal economist and a judge. I'll apply some law and economics, and it essentially does a cost-benefit analysis. But his cost-benefit analysis was premised on the idea that he himself had to be shown that negligence was a bad rule, that there was something inefficient about negligence, not that it was before he would not stick with negligence. He could have, that's just a presumption. It was just a burden of proof that he just concocted in his reasoning that led him to the conclusion. And then finally, when he went to justify it, when he actually addressed at the end of the opinion, the fact that there would be a community that would be bearing these costs, he more or less said that that's kind of tough. That's life. And by the way, it's not clear that they shouldn't be liable. And here it becomes really key here. I'm not quoting directly. This is just from the top of my head. But essentially says the residents around this toxic spill chose to live where they chose to live. And they knew they were living in a space where, railroad cars are, being moved around and shifted about. And so there was this risk. And then he literally said something very close to, it's like choosing to build your house between the runways at O'Hare Airport. So notice what he did.
It's just like the Irish girl.
Exactly. And that's exactly what he did. He puts consent in there, and it's not part of the legal reasoning. It's just his little analogy at the end to make himself feel better about this outcome. But back to another point you made, if I may, which is, you pointed out that this works in as much as we in society see it and don't see it for what it is. Right. And that we don't understand, oh, he just added consent to this when clearly there wasn't consent. Right. Or he provided a story that legitimated this outcome. But if you look closely, it isn't legitimate. And what's happening, for example, in East Palestine, I think, at this moment, and by the way, this will be reshifted, soon enough. But right now, it just seems like the stories that would be told to justify what's happening. First of all, there's no real risk. It's no big deal. So we've got this. Second of all, we all benefit from chemicals being transported around our country. And, all of those kinds of stories, including the one that's not being told, hey, people chose to live here. Those stories aren't plausible. And so there is real anger. There is a real sense, hey, there's an injustice here. Because what we really see is a company that has been avoiding and evading liability, has been doing everything it can not to, to avoid safety regulations, to minimize what it's obliged to do, to minimize its relationship with labor and how much time labor gets, to have vacations or get a break, how completely stretched out the various actors in the system are. And it's been pursuing profit at all, as its ends, and it's visible in that plume, right? That giant plume of toxic chemicals says something visually that makes implausible the idea that this is a community that chose this or is better off because of this.
Right. There's also this interesting political thing that's happening where conservative news has decided this is an opportunity to skewer the Biden administration and Pete Buttigieg, which I personally have no problem with. But it feels kind of like they're doing it for political reasons. It's a Trump heavily Trump plus 40 county or something like that. And the narrative they're going with is that Democrats don't actually care about this because it's Trump country. They don't really care about the environment. And this shows that all of that is a pretext. Why isn't Pete Buttigieg here? The EPA is a failure. Also, we wanted to do more, but also it's a failure. And they're using it to kind of retread various scripts that are convenient to the or part of the right's narrative. But at the same time, in doing that, they are showing they have to show a great deal of compassion for the people in the community. So there's this weird catch-22 where the issue is being elevated, the incident's being elevated by the right for their own reasons, but at least the community is getting attention, and you can't be mad at that in the least. At the same time, that obviously the left is engaged with it for substantive ways. And I don't know, like the part of the liberal media institution that's kind of in lockstep with the Biden administration is a little bit in a difficult place because it wants to kind of show sympathy at the same time that it is very defensive for some reason of Pete Buttigieg and his actions. But that's all to say that to the extent that we might expect the right to be running with some of those system justifying scripts and saying that these people deserved it and what have you, they're not doing that because it's politically advantageous for them not to do that in this moment. And that's inuring to the benefit of this community, frankly.
Yeah.
So yeah, go ahead, please.
Go.
Yeah.
No, go ahead.
No, you go ahead, because I was going to switch gears a little bit.
Well, I just think that's such an insightful analysis, and one reason why I like listening to Bad Faith. Um, may I comment on it?
Please.
Um, so let's go back to corporate law class, if we may. So you get to the first year, and all the things I said about sort of the reinforcement of existing power is in wealth is what those courses are devoted to. But then you start taking other courses in your second and third years, and among them is corporate law. And corporate law feels like it's this regulatory body that is meant to govern and regulate and limit what corporations can do. But as you reminded, me before, that one of the lessons is no, it's really meant to simply govern the relationship between shareholders and managers and directors, right? That's the relationship. So all the other stakeholders are really irrelevant. These days, we pretend they're irrelevant. We pretend they're relevant, but there's no meaningful accountability to other stakeholders. And that's what corporate law is. And you get into the details of corporate law, and there are all these sort of doctrines within that space of, how do we worry about shareholders or not in this context? But what's really going on, Briahna, is that law is a mechanism of empowerment. What corporate law is, if you think about it, is simply the law that allows investors in corporations to unionize. And it says, if you invest in a corporation, and by the way, there are good reasons to do that, because you can take a lot of money from a lot of people and aggregate it and make that money much more productive and profitable. And it can all be directed towards some shared mission or goal that then will be in the hands of a small group of managers and directors. In other words, you as capitalists have unionized, and you have turned over control and power about decision-making to this small group. And they now can use that money in any way they want to serve you. And we are telling them they have an obligation to serve you. So we give them legal cover and moral cover for pursuing profit and disregarding the harms of the corporation on every other stakeholder, including labor. So that is power enhancing. But that's just the beginning. Because what corporate law does is say, and by the way corporate law is produced is through a competition among the states, where little Delaware has won that competition by providing to large corporations the terms of governance that that appeals to the decision makers for corporations. So it's not law that's being imposed, it's law that's being consumed in a marketplace of laws. And what Delaware has done is managed to provide such attractive law that it attracts a significant majority of the largest global corporations in the world that are US-based and Delaware-based now. And those companies now all have a shared common interest. Their common interest is, we want more markets, we want less regulation, we like stories that make markets look good and stories that make regulation look bad. And we want to interact in the political process and in every other interaction with institutions, if it's the media, if it's academia, if it's any other institution, with those goals in mind. And guess what? We have the same goals. So now with the same goals, it's like a union of corporations. They are operating implicitly with one single shared goal. Well, we know what that does to political outcomes. Those who are operating with a single shared goal disproportionately influence what happens, add wealth to that, add power, connection, all the lawyers and lobbyists that they bring. And you've really got a source of profound hegemonic power. Now, we're not done, because now we've got other areas of law. I mean, part of what corporate law, you may remember, is the sort of allowing mergers so these companies can get bigger. Think about antitrust. What antitrust law is the allowing of sort of the aggregation of several corporations into one bigger, more powerful one. Now that one powerful one has all these other stakeholders with whom it's interacting, and it's even more powerful. It's the only game in town, right, for lots of folks. So again, that's about aggregating power. Then you have the just, you know, decisions by the Supreme Court and conscious decisions by corporations to say, let's work together to build think tanks. Let's get involved in actively in how we, in our philanthropic kind of investments in law schools or universities. Let's own the media. Like all of that, all of this becomes more mechanisms of power. So at the end of the day, what government and all the institutions in our society look like under this legally constructed hegemonic power is they look like institutions that are operating independently, but they're all more or less captured by shared corporate interests. So when you go to this question, I think this is what the right is doing. They're saying, oh, look, the government is bad. And by the way, the current administration is to blame for this, not decades of capture of, administrative regulators. And so they are really just using this as an opportunity to first blame someone they want to lose in the next election. And secondly, to further the deregulatory sort of movement to further enhance the power of corporations. And you see the vicious cycle, right? Law is a reflection of existing power, but it also produces that power, which then allows capture to be that much more significant. All right, I've gone on a long time in my supposed...
This is so great. And I've been reminded of a bunch of other things. One is that you started, if I recall correctly, again, this is almost 12, 13 years ago for me. I remember you talking about the founding fathers' conception of the corporation. And in contrast to the kind of ever expanding, hegemonic, democracy toppling corporate world that we live in today, an oligarchy, if you will, they had a conception of a limited grant of corporate power that was geared toward doing the things that needed to be done in a new country, raising large amounts of money to build bridges and roads and things like that, but that they were very conscious of the potential democracy undermining effect of allowing corporations to go unleashed. Am I remembering that correctly? And explain that a little bit more and why that was important for you to set out for us at the top of corporate law.
Well, that is correct, and it was important because, especially at the time, less so I would say since 2008, but it was important at the time to clarify to students that there was nothing given about the emergence of corporations as this great source of power in our society, and that those who would appeal to tradition or what the founders thought, or to what we think of as like some American exceptional way of thinking, they should be reminded that there was tremendous trepidation about the potential power posed by the creation of these institutions, which would have a single goal. And so they really tried to contain it and so forth. Now, it's easy to see that and say, well, look at them defending democracy. But it's also, let's not kid ourselves. They were protecting a particular form of power and sort of allocation, aggregation of power that they wanted to maintain in the state, which itself had all sorts of injustice. And it's worth understanding that what corporations and corporate power are doing is not unusual. That is, institutions over the course of history, recorded history, have always been vying for legitimacy, ability to create and build and maintain power, and of course to use the law in that process. And you can think of the last 150 years or 200 years as this competition roughly between, say, nation states and corporations as not just harmonized institutions working together, but really as competitors with each other. And you can look at different times in history and say, what's happening in the New Deal? What's happening in the New Deal in part is the state trying to grab back some of the power that had come from that it had been taken during the sort of the Gilded Age and on, as the greater monopolization and trust and sort of corporatization of that time period, the Lochner era, all of that. It's trying to grab back some of that power, does so, and corporations are going to come back and fight again in the early 1970s, they're going to fight before then, but it's really going to pick up speed in the early 1970s.
So I want to focus on that as well, because you did this lesson on the Powell memo. That is one of these other like aha moments for me in understanding the last 50 years of American politics. That your lesson on the Powell memo combined with Thomas Frank's book, which in large part kind of traces the political version, like the aftermath of what happened, were so transformative to me. So why was the Powell memo so important, especially as we're talking about these tipping points? So you have the Gilded Era, you have the state trying to wrest back for some control. We get the New Deal era. We talked earlier about how we have this just world hypothesis, but sometimes things get so bad that no one can rationalize why we're running the world the way we do, and there's this revolutionary moment. How does the Powell memo fit into all of that?
It's such a good question. You have such a good memory. It means the world to me that you have this recollection. Yeah, I remember teaching the Powell memo before it became like something that everyone was aware of. And so as someone who likes to, occasionally wow my students, I've had to give up the sort of impact, the oomph that Powell memo has now, because everyone has read it. But
have
it is well, maybe not everyone, but increasingly, and that's a good thing. But let me try to put it in context, if I can, as you asked. So imagine, we've come out of the New Deal, and then you've got World War II, and World War II is one of the lessons of it is, hey, we're great and we're about freedom, depending on the spin, and we deserve our sort of global preeminence in the economic space, because and our model of democracy, or representative democracy, and freedom and capitalism all stand for this potential of that all of us should aspire to, and now we want to wield that dominance and take advantage of the fact that much of the world is recovering from a world war. That story is being told. Corporations are looking good at this moment, having done so much in World War II to increase production, et cetera. And suddenly, by the 1960s, the bloom is coming off the rose of pro-corporations. In some ways, some of the lessons of the early 20th century and the New Deal are coming back. Like, wait a minute, we're not such a pretty place. We've got civil rights movement happening, clear racial injustices in our own apartheid system that is in place. That's not looking like freedom exactly. And then if you look at what corporations are doing, increasingly, it looks like they're pursuing profit without regard to the consequences on many of us in our future. So, take as clear examples Rachel Carson and Silent Spring, to pick up this idea of the environment and its significance. That is a book that is, among other things, revealing the harms being done that are otherwise hidden, and lifting them into prominence, as you say, and making salient what now feels like an injustice. What is Ralph Nader doing with Unsafe at Any Speed? Same kind of thing. So we emerge from the New Deal with a whole bunch of kind of responses to the inegalitarian tendencies of the early 20th century, partial, but still responsive. And then we emerge in the 60s and early 70s with these new stories that are making corporations look bad again, and new regulatory responses, so that even President Nixon is, advancing the EPA in 1970 or 71. Add to that the racial unrest that is incredibly salient in the 1960s, right? And 1968 in particular, with riots in the US and around the world. And that is a moment in which business said, we need to come together. Now, I'll go back to my tobacco story. Tobacco had weathered this storm in the 1950s where the evidence had come out that their product could be killing lots of people. And they had to figure out a way to navigate that through public relations, and they did. And the key two aspects of that solution was, one, we're going to create doubts as long as we can. And two, we're going to promote freedom and choice as much as we can. Where there's doubts, we can say, look, we didn't do it. And where there's freedom and choice, we're not responsible for having done it. And so both of those strategies worked up to a point, but around 1964, the doubt one is itself losing its purchase culturally. Back to our point, it's just too obvious by that point that tobacco is killing hundreds of thousands of people. Too much evidence. So they really then lean into freedom and choice. Okay, so now that's the tobacco example. And guess what? They keep their profits coming. They keep selling cigarettes. They keep moving forward as if there is no real risk. And now, as of the late 1960s, all of corporate America is feeling like they're on their heels. And especially those that are producing chemicals or pharmaceuticals or any of the number of the the oil and so forth. Like those companies and industries are feeling at risk.
Because also, so wasn't it part of the issue that those corporations were churning out all of the stuff that was needed for the war effort? It was no longer needed, and they just started putting all that stuff into our bath products and what have you. And some of that was cancer causing and harmful. And now they have to start justifying how they're going to keep selling this stuff and what they're going to do with it in the alternative.
Yeah, I mean, it looked really good in World War II from some perspectives, but then suddenly they're like, when they go to turn their swords into plowshares or whatever, what their swords were chemicals.
Yeah,
in many cases, and what their plowshares was, well, I don't know. Let's put this in our house. Let's put it on our bodies. Let's put it in our yards, and let's put it on all our crops. That was sort of an evident pursuit of profit without consideration of its consequences, and those consequences were coming home, right? They were being realized. So you're now in the late 1960s. Big business feels like they're very much on their heels, and guess what? They need a new story. They need some way of justifying what they're doing. And so at that moment, Briahna, whole bunch of intellectual ferment creates this whole collection of ideas and strategies. And so it's in 1970, 1971, in which Milton Friedman writes for the New York Times Sunday, for the Sunday magazine, a piece on why shareholder primacy should be the primary goal of corporations, that is profit. Corporations should not have to take into account any effects they have on stakeholders. It should just be profit, and doing otherwise would be unadulterated socialism and bad for the world.
And it's important to note that, there was a time in American corporate history, not to be overly complimentary of the corporatist of yesteryear, but there was this kind of built-in assumption that there was a kind of benevolent noblesse oblige that these corporate titans, the Carnegies of the world, et cetera, owed to the general public, owed to labor. They should build museums and generally take care of the workforce and not just so openly, doggedly pursue profit as the only objective.
That's right. They were at least, they had some apparent scruples about what they were doing and when they were doing it. They would lose it from time to time. And when they did, the law would often respond. But what Friedman was saying is, let's stop confirming that view that we should feel bad, and let's lean into the idea and start selling a different story that pursuing profit is what is going to lift all the boats. So this is the emergence of neoliberalism in some sense, and also the source of the corporate law class that you took. Right. So when Milton Friedman is saying we should concern ourselves with profit and profit alone, he is also saying we should disregard stakeholders, which was the question I asked to your class, right? Do we care about stakeholders? It seems like we should, but we don't. That's because Milton Friedman's idea, which was absurd when proposed, quickly took on supporters. Where from? business who began really promoting this idea everywhere, and in legal theory and law and economics. What emerges in 1970, 71 at that same time as well, that's when Robert Bork is writing his book on the antitrust paradox. He doesn't publish it for 8 more years because of student protests and health issues with his wife, but he is writing it in law review articles and selling those ideas about antitrust. So again, we see the ideas that would justify the growing power in the legal system emerging at the same moment. It's when Hayek would write about his pro-market anti-regulation in his like 3-part series on the topic in the 1970s, also very much in response to what's happening in the 1960s. It's when George Stigler at University of Chicago is writing his article, very famous Nobel Prize winning article on regulatory capture. And so what does George Stigler argue? He says, look, don't trust what those regulators say. They say they're serving the public interest, but we all know they're beholden to corporate interests. Wow. Like I always say that I learned my sort of critical progressive position from George Stigler. That seems right to me. What is remarkable about George Stigler's famous article was it still captures a lot of how I think we should feel about the regulatory system. But his conclusion was the response would be that we would deregulate, not that we would build insulation or capture resistance into our institutions. And he acted as if this idea of capture was new. This idea of capture was there, from the beginning. It's just that what he really wanted to do with that idea was to apply it to administrative regulators, not to any other institution, not to the education system or the media or anything like that, when the same arguments would apply there as well. And his conclusion was we should deregulate.
It's such a bizarre libertarian fever dream to accurately identify capture and say the fact that corporations are controlling the administrative state means that they're rigging the law to advantage corporations and it's hurting people. But also, the solution to that is to get rid of the regulatory state so that nothing constrains corporations whatsoever.
Right. That was the conclusion. It's that, and it was also because they played a kind of a parallel script that went along with capture. One of the arguments was that they would say that what regulation is doing is limiting entry, that it's an industry limiting entry from competitors, and therefore we have this problem of antitrust. But of course, at the same time, their buddy Robert Bork is writing, and let's let them build. Like there's nothing wrong with limiting entry and becoming bigger. It just means success. So there was no consistency across the collection of arguments that were being made that together form the basis of law and economics, the dominant theory for legal theory as it exists, and neoliberalism generally. And it's, by the way, at this moment, Briahna, that our friend Lewis Powell, right? He's about to be nominated by Richard Nixon to the Supreme Court, another Harvard Law grad, an LLM student, and he had been a tobacco lawyer, was on the board of Philip Morris, was a Virginia lawyer, and he was familiar with these tactics, and has someone who has spent the better part of a decade immersed in tobacco documents. What the Powell memo is a beautiful summary of the strategies and tactics of tobacco, distilled to a readable number of pages and generalized for all business and not just tobacco industry. And that's essentially what he called for. He called for, look, we're threatened by this outgroup of people who are anti-business and anti-American, and we need to come together and we need to invest together. We need to go after the judiciary and prevent the judiciary from undermining our power as it would be, say, for example, in tort law at that time period, or even in contract law in that time period, plus the regulatory institutions that are taking shape, right? And we need to do something about the media. We advertise in the media. Let's use that power and money as a mechanism for influencing what they say, and why not own them? and our donations to academia. Let's start investing in a way that is conditional, not here's some money, put our name on a building and we'll be happy. It's here's some money. I'll give you some more next year if you do things that serve my interest. We're not going to make that too explicit, but we're going to pick and choose who we're financing. And that's when they discover, by the way, law and economics. Those people who are doing law and economics are saying things that align with our interests. Let's promote law and economics. And so law and economics in this collection of ideas, it emerges. And Richard Posner is the recipient of these benefits. The last thing I'll add to this is that this is tort reform too. Tort reform is just deregulation in tort law. And tort reform as a movement is highly subsidized across many contexts by interests that want to minimize tort accountability, which brings us back to what's going to happen in East Palestine.
So for people who might be maybe too young to remember the tort reform craze of the 90s, it was a real political movement that said that America is too litigious in these judgments, the victims are able to win are too high, and there was a lot of demonizing people like the woman who won the judgment against McDonald's for spilling hot coffee on her lap, which many people perceive to be a case of judicial overreach because they don't know the facts. But of course, this was, I think, the actual first day of torts that we would go through the McDonald's case, and we learned that she wasn't driving, she wasn't negligent, she was parked in the parking lot. Her son was the one that was driving, and the coffee was so hot it burned her down to her bone. Something that this isn't like a little scalding. Like, why on earth would any coffee in any circumstance be that hot? When people know the facts, they understand that judgment was a good one, even though it was later lowered by the courts. However, the fact that we all think negatively about her in the public imagination, the fact that we think there were all of these kind of too big, irresponsible pharmaceutical judgment and this idea of ambulance chasers, all of that is part of this kind of cultural movement to vilify the idea of tort law as being this tool that could actually control, limit the kind of ineffective production of bad externalities by these corporations. And that, to your point, does bring us back to this train situation. And I want to come back to it because you've said the word efficient and made reference to efficiency several times, but I don't know that we've actually explained what we mean by that and why it is that we're hoping that corporate law should be designed to make corporate behavior more efficient. Yeah.
Well, again, I just want to commend you on your last summary of the McDonald's case and your recollection of the course, and that was terrific. And I just will supplement that by, a big move of the tort reform movement was to use that case as a way of illustrating how markets actually work and how whatever happens to someone when they buy a cup of coffee is on them. We all like hot coffee, right? And this was. And the way it was portrayed was we have these ambulance chasing, greedy plaintiffs' lawyers. And by the way, they're like other actors in our system. They are trying to make a living. They're simply attacking an innocent victim, that is McDonald's. And by the way, all the consumers of McDonald's, by having someone shift responsibility that should be her own for having chosen this product. So again, we don't care about what happened to her because she chose it. And now she is deliberately, in a kind of malingering way, trying to impose her desire for money on us. That's the story. And again, these kinds of stories are being told where if you step back and really look at the context and really look at the truth of what happens, it's very different. Fortunately, the story on McDonald's has been retold enough, the truth of the story, where that no longer works. But in other contexts, those stories are still happening. And I just would also say, the connection of tort reform to deregulation is connected as well to anti-union policies and emergent. I mean, all of this is cut from the same cloth. And it's worth understanding that some of the same premises are underlying all of this. And as each of these finds expression in the law, it further empowers corporations in relation to those institutions that might challenge it. So it might be tort lawyers and tort victims, or it might be labor and the ability of labor to unionize. But understand what's happening is it's a shift in what are the power dynamics, and the law is facilitating that shift. So back to your question on efficiency.
Yeah, but I will say, just before we get back to efficiency, I did want to say about the Powell memo that, you taught it as very much like a blueprint for how the conservatives were going to reclaim prominence at the tail end of what had been several decades of various movements. The labor movement in the 40s, civil rights movement in the 50s, women's rights and gay rights movements in the 60s and 70s, all coming together. And they felt like there was a losing battle, and they had to regroup. And your point, I don't want their points about the media getting lost and the influence in law schools and educational institutions as well. I have a friend, a coworker who, we get in this fight constantly because he says, well, these are liberal institutions that are propagandizing kids. And I'm like, LOL, if you think that institutions like Harvard are liberal, I mean, like you can find your odd Professor Hanson, here and there. But it's baked into so much, as you were describing with property law and all the first year courses. It's baked into how you think about the world, and it's not politically taught. You don't think you're learning politics, but you're learning a fidelity to the institutions that were designed not to serve the majority of us. And it's so much of that is baked into the rules, the plan of action that was charted out in the Powell memo. And it's the origin of Fox News. It's the origin of realizing with the advent of television, how powerful ad buys were, how powerful it is to go ahead and say, ask the question, why do we have commercials for Raytheon on MSNBC? Well, if Raytheon is contributing to the funding of these programs, then how is that going to affect the coverage, and on and on and on. So it's just such an important moment in American history. And once you understand so much of what's happened from the 70s till now is not accidental, but a part of that plan, I think it's also a wake-up call to the left to think more clearly about long-term planning and how we're going to push back against that. But I'm sorry, go back to the question of efficiencies.
Never will we get to efficiency because these topics are too good. But I just think you're so right. It's such a lesson for the left. That is, what succeeded were ideas and stories and legal changes that enabled organizing, that facilitated organizing and coalition building, and a deliberate choice to do that. And I totally want to credit the Powell memo as summarizing the strategies that were very explicit about. We have to come together, like we have to overcome our differences. We have to work together because we share a common threat, right? That idea they were employing. That is the strategy that in some ways they're co-opting and adapting from the left up to that point. And it is extremely effective because they are able to enact that practice and then get support from the law itself. Whereas I think the left has had a much more difficult time of doing that. Anyway, I'm prepared to talk about efficiency. So if we can remember the question, it went something like this: when legal economists speak about what the normative goal of law should be, what should law be trying to do? Should it be trying to advance justice or somehow be true to the goals and meanings of the founders? Like, what is the law supposed to be doing? The dominant answer in the late 20th century for much of law was it should be trying to advance the goal of efficiency, which raises your question, Briahna, what is that? And the truth is the answer was never very clear. Instead, there were a set of definitions given. We won't go into the details of it, Pareto optimal, Caldor-Hicks, any number of descriptions you might provide for efficiency. All of them, though, led to a set of presumptions among legal theorists that markets would achieve efficiency more effectively than any non-market institution or process. So the consequence of efficiency as a norm was we will get there as long as people have the ability to choose and no one else imposes their views on people. So we're back now to a story that would justify and valorize choice over everything else. And again, what have we done? We've ignored context, we've ignored history, we've ignored circumstances, but all the things that the law had basically been doing back in the Lochner era, right? It's now going to do again, but instead of classical liberal justifications, it's going to have efficiency as the goal. Sometimes this norm of efficiency was justified as, look, you value something more than I do, it should be in your hands. And so what we've done is increase the size of the pie, right? So increase the size of the pie, that's what we mean by efficiency. But of course, it ignores the fact that you may value something more than I do because you are a successful podcast celebrity and all-around badass, and I am an unknown. And so that willingness to pay point that we talked about earlier is really not picking up something that most of us normatively care about. The response to that is, oh, don't worry about that problem because we can still use the legal system, say the tax and transfer system, whatever that means, to reallocate wealth and income in ways that align with our distributional goals. We shouldn't focus on distributional goals when talking about most elements of law. We should just maximize the size of the pie. But when it comes time to dividing the pie up into smaller pieces or into shares of pie for different groups and individuals, we can insert the law to do that in a way that comports with our egalitarian or progressive ends, whatever they might be. And if we don't have them, that's a matter for the legislature, like hands off. Of course, the problem is that assumes that those institutions exist in ways that aren't themselves captured by the winners in the pie maximizing contest. And it's right back to my point. The law then creates rules that advantage the haves. Willingness to pay ends up being a measure of whether you should have something. And then once you have it, you have a better ability to influence and capture the system itself, including the tax and transfer system, whatever that might mean.
So I remember you giving this example in law school, because here's why it matters. To go back to the train example, we were talking about wanting to get the train companies to internalize the cost of their hazardous behavior, their high risk behavior. And if it's so difficult for various reasons for the people harmed to successfully not only bring a claim, but also for that claim to actually account for the real world harms. And how much are you owed when you're given cancer? Can you even prove that your cancer was from this particular spill? Causation. I mean, when you first introduced the concept of the strict liability, saying, well, all you have to do is prove causation, it's so much better than the negligence standard, but still that is very, very difficult, as we learned from, watching Erin Brockovich 20 years ago. So but that being said, it's still better than the alternative. How do we get them to? The idea is if they actually have to pay for the damage that they've done to the environment, to human beings, to society, then maybe their behavior would change because the cost would be so high that it's actually more efficient for them to drive the train slower, install the higher quality brakes, hire more staff, allow the train conductors and engineers to actually take vacation days, all of these things. And the example that you use to help us understand how forcing people to internalize costs and how liability standards can have more efficient outcomes involved Coca-Cola bottles, cans versus bottles. I'm sure you remember this because this example, I don't know, this was a huge light bulb moment for me as well. And I have tried clumsily, I believe, to explain this on the podcast before, but I want you to give the people the unadulterated by 15 years of not being a lawyer version of this.
So, first of all, I'm proud to say that I no longer take students through that elaborate example.
No, I loved it so much.
But I do mention the case on which it's based, which is Escola versus Coca-Cola. So much of what you said there, I just can't leave untouched because part of what you sort of separated was the question of what should be the liability rule that applies. And then also you said there's all this other stuff like how do we measure damages? Right? Who gets to bring a case? Who has standing? What do we say is preempted and not preempted? Like a ton of these things. And if you think about the lives of the people in East Palestine, you might be able to say, I can come up with some economic costs that we can measure where we could imagine a tort system being responsive. Healthcare costs associated with short-term and long-term consequences, property value loss, which is going to be real, right? Going forward, but even when we get to those things, we think, well, some of these effects are going to be generational. It's going to be impossible to estimate them, and probably the courts aren't going to be willing to make much of an effort. So that's going to be lost. But there is so much damage that is done by one of these catastrophes to the people and their view of themselves, their identity, their sense of control, how depressed they are, how much stress they're under, substance abuse, all these things that are connected with the dislocating and disempowering effects of these kinds of explosions that just aren't going to be picked up. And before we talk about, how strict liability might work, I want to underscore that point, which should make us think about how much more we would regulate ex ante before the fact, these things, and be mindful of those things. And maybe also what else we might include when we think about real accountability on the part of corporate actors. To the actual example that you pointed out, the argument that I was making at the time was that a fundamental question in tort law has always been, well, who should pay when someone behaves in a way that's perfectly acceptable, or both parties behave in a way that's perfectly acceptable? How do we deal with the fact that accidents happen, that random things happen, which is not our case here? This is not random. It's, people could have done things. And there, the law has decided that it's going to leave the harm on the victim when both parties are taking adequate care. And my intuition, and I really have never heard a plausible reaction to it, is it should be borne by the party that created it. Here, it would be the railroad or those who put these chemicals in transit in the first place, or a combination of those two, not the town. And even if you say there isn't negligence in that case, even if they did everything right and it was a fluke accident, I still think they should pay. That's what strict liability would do. But instead, the law has said we have to show negligence, and to show negligence, it's really very difficult. It's a difficult task. Now you got to also bring together a class and have a whole set of procedural hoops that you have to jump through. So there's a whole bunch of other things, but one thing you have to do is show negligence. And what negligence does really is insulate the producers of these harms from so much of the consequences of their harms that they are they're immunized from it, but they're also disincentivized. There's no reason for them to say, well, you know what, this transport of acrylonitrile, or name the chemical, from here to there doesn't really get me much profit, but it does get me some profit. Well, that's dependent on the fact what you're measuring is a consequence, or sort of built into that calculus is a judgment about what your liability is going to be. And if liability is saying you're not going to pay unless we show you did something wrong, then you're going to do it. But if you, on the other hand, are going to be liable for sending that, even if you didn't do anything wrong, you might say, you know what, I'm not sending that last 12 train cars full, right? So you might adjust how you do it, or where you send it, or you might move your factory closer to the source of your chemicals, or any number of things that we're doing, all of which are being sort of taken out of the calculus of the individual decision makers. I think this stuff is relatively trivial in the grand scheme of things, but it's still, still important.
I think it's worth also noting, to imagine some people might have a difficulty understanding, what is this? How does an accident happen absent negligence? Okay, well, there's a world where some percentage of the time a train, a car is going to get stuck on the tracks, and that's not the fault of the railroad company. Mm-hmm. It's going to be that a deer runs across, or there was a act of God and there was a tremor overnight that disrupted their rail. It was something that they could not have predicted. But the idea is these things are going to happen, and who should be the one that's more responsible? The person who's profiting from this thing, the person who has the most ability to control the scenario, or the rest of the general public. And the other point I just would add is that in real life, if the obligation is for the harmed party to prove negligence, you're in a situation where you're hoping that through the deposition process, the person that wronged you is going to disclose information that proves they knew that there was a risk here that they ignored and could have controlled for, that you're going to get those documents and you're going to be able to prove it in court. And in real life, corporations are very good at not ratting themselves out in that way, which is why it took so long to prove so much about the cigarette industry, why Aaron Brockovich was such a trooper in figuring this out and getting the documents. Remember, they dumped all of those paper documents on her. They figure out ways to make it very difficult to find that red herring that would make them actually liable. So we're talking about in theory of even proving negligence, and in real life and proving negligence, it's just an incredible hill for an under-resourced plaintiff to have to surmount.
I have nothing to add to that. That is absolutely right.
Okay, so quickly, I'm so sorry. You don't have to go through the whole Coca-Cola thing. You can summarize it in like 3 sentences, because I know that we've gotten kind of the gist of it. But I just thought it was such a simplified example of how all of this can work.
Well, I will add some more to that then, because one of the ways in which it became clear to me that I was not the typical legal economist back in my early career was when I was going to law and economics events arguing for tobacco manufacturer liability. And everyone else in the room, except Elizabeth Warren, who was there early in my career, was like, what are you talking about? People choose to smoke. Let's move on. That summarizes much more elaborate conversations. But my sense is that had tobacco actually been meaningfully liable, it would have had a profound effect. It may well have shut the industry down, which I would consider, not a bad thing. And by the way, those people who are against tort law or deregulatory in so many ways, all they do as their basic script and story is argue that capitalism and markets do things better because capitalism depends on the information being included, and all that information gets calculated, and we don't have to judge what is desirable or undesirable, or in their terms, efficient or inefficient. And my response was, yeah, but no, like if you're true to that view, you would ask whether in fact all of these costs are internalized before you would be satisfied. And by the way, every time I talk about some cost being internalized that's otherwise clearly being externalized, you say that's bad because of choice or some other story that you have to say to make it bad to internalize it. But in my view, if internalizing the cost of cigarettes on the industry and in turn perhaps the consumer in the price of the cigarette or the Coke bottle means that they don't buy it, that's the market working. Like, why is that inconsistent with what your fundamental premise is, that where you're starting? And in there, I think I'm a fan of more liability. I mean, this is one step that they should accept. And if you did, it would change how much care they take, change all the factors you described a moment ago when talking about Norfolk Southern, and it would also change how they advertise, who they target, where they sell things. If it were tobacco, for example, instead of targeting children, if they were meaningfully liable for the consequences, children would be the last people because they are the most vulnerable to the harmful consequences of the toxins that are inhaled, et cetera, not the first people that are targeted. And through liability, if we actually had a liability system made sense, we could make a lot of headway on many of our public health problems that we're not able to make now. We can make a lot of headway in terms of changing how we live with all kinds of transportation accidents and environmental catastrophes that we just move on from. Now, we'll do the same with East Palestine, unfortunately. It will be another footnote to add in a series of footnotes of moments in which the public attention was galvanized long enough to say something wrong there. But there will be another sports event coming up soon.
Yeah. Baseball season starting.
By the way, I'm for that. That's separate.
All right. Well, okay. So we've been here for like an hour and a half. I have in my notes, but what about piercing the corporate veil and the business judgment rule? And what is the likelihood of, companies like this, even if they do have a judgment, of being able to basically dissolve, get bought, and evade liability? I remember finding all of that actually very confusing, more challenging parts of corporate law. But I think what we'll have to do is have you back. Hopefully this desensitized you to some of your anxiety around doing these kinds of shows. Because from my perspective, this has been amazing. I'm so grateful to be able to pass on lessons that cost me $160,000, $80,000, whatever it was, dollars a year or total, to the general public for free. And I'm so grateful to you, Jon, for not just being here today, but for being such a resource for so many of us and being so transformative for so many of us. I'm not the only one. Vanessa A.B. was a Section 6er. Josie Duffy, who people who listen to this podcast might be familiar with, kind of a criminal justice advocate, and also podcaster and journalist, was a Section 6er. You have really shaped so many people who I admire in the left space right now, and I'm sure any number of people who are not podcasters and who I might not be aware of, but are doing good social justice work in the real world. So thank you so much for the time you've spent with us today and for the work you do every day as a law professor.
Well, that was such a nice thing to say. Thank you, Briahna. I just want to make very clear my admiration for you, what you've been doing since law school, and in law school, not to minimize that.
No, we don't have to pretend like I wasn't completely shy and quiet. I didn't hardly say a peep in either class I had with you. You probably were like, what on earth is going on with this loudmouth? I don't even remember her being in class. You're probably shocked.
You have come out of your shell. You have come out of your shell. I didn't see this coming exactly. But I think it was all this pent up stuff that you were carrying throughout 3 years that has made you especially eloquent and effective in what you do. It's just an honor to be to be connecting with you and to be part of this show, which is amazing.
Well, I appreciate you saying that. I hope we were able to get you back. Can you tell the listeners where they can find you on social media, anything that you've been writing or any other projects you've been working on?
I recently finished an article with a co-author named Jacob Lipton called Occupy Justice that looks at the meaning and potential significance of justice as a norm in law. Social media is relatively new to me, but I'm trying to make up for lost time, and you can find me on Twitter, I think, at The Situationist. Long story. And some of the work I'm very proud of includes the work my students are doing in a class that I teach. And the product of that class is in a magazine called The Flaw, which you can find at theflaw.org. I'm sure there's more, but that's a good start. So really appreciate it, Briahna.
It's truly, truly my pleasure. Thanks to all of the listeners, as always, for tuning in today. If you want an extra episode of Bad Faith every week, you can subscribe at patreon.com/badfaithpodcast and get those that drop every Monday. And I will definitely be seeing you later tonight on Call-In to discuss today's episode. I suspect a lot of people are going to have a lot of thoughts, and I obviously have more than a podcast worth to say about all of these subjects. So I'm really looking forward to continuing the conversation later on tonight. As always, take care of yourselves and keep the faith. Hey YouTube, thanks for watching. Just a reminder that this is a podcast. You can catch an extra premium episode every Monday for $5 a month at patreon.com/badfaithpodcast. That's patreon.com/badfaithpodcast for $5 a month, an extra episode every week. Additionally, please do consider liking this video, subscribing to this channel. It helps us out. It helps independent media beat the algorithm. We appreciate you. And as always, keep the faith.